All right, so we're going to go ahead and get started. My name is Stephen Bishop. I work with the NC FarmLink program with NC State Extension. And I would say for about the last 5 or 6 months, we've had a working group of extension agents and extension staff who have been trying to brainstorm ideas and ways that we can increase our capacity as an organization to help farmers with some of these transition and succession issues. And so we sent out a survey about 4 or 5 months ago, and we tried to get feedback on what issues you felt were most important for farmers dealing with transition issues. And one of the highest ranking topics was just basic estate planning. And so that's what we're going to be talking about today. So today we'll get started with estate planning. And then also in February, be on the lookout. It will continue into the February webinar. We'll be talking more about estate planning and trust and LLCs. And then after that, in March, we're going to be talking about conservation easements. So we've got this whole series based around farm succession issues that we're just trying to get information out to agents that they'll feel more confident helping farmers with some of these issues or directing them to resources. So today, we're really lucky to have Andrew Brannon with us to talk about basic estate planning and transfer issues with farms. Andrew's got a ton of experience in this area, real life experience working as an attorney with farmers on farm transition issues. So I'm excited for him to get to talk to us today. Just some housekeeping. If you have any questions, feel free to put them in the chat. I think Hannah is going to be monitoring the chat. So we'll pass along any questions as they come up. And then after the webinar, we'll also have some time for question and answers. So with that said, I think I'm going to go ahead and hand it over to Andrew and let him take over.
Stephen, Hannah, thank you. I appreciate the invitation to do the webinar. Hey, everybody, thanks for coming in. I think most of us are with Cooperative Extension, and I think a lot of us know each other well, and a lot of y'all have seen me discuss these materials in your counties and in front of your clientele there. And so I'm going to try to deliver what as described in the advertisement. Because I want to really start with a caveat, and I'm saying too much, but I've been working on this in this space, so to speak, really now about 20 years. And as I was approaching today, and really this week, I have some other presentations in other counties on this topic. I was kind of trying to go back to square one and think about, how have you talked about this in the past? Because after I've been at NC State now for 6 years. I've been working, now I'm work for Cooperative Extension. I've been working alongside Cooperative Extension for a long time. After my experience in private practice, the whole topic of farm succession, to me, because that's how I made my living, was doing the wills and the trusts and the land transfers and all that, became one really of it was certain that they're documents that are looking to the future to dispose of property, direct where the property rights are going to go. But all the stuff about the business planning, the strength of the business, all of that, I left sort of to the side and let other people take on those topics, and I focused very much on the legal instruments. And so as I talk about this topic today, what I proposed to Stephen and Hannah and Noah was, how about let's do this in two parts. Let's go through the kind of the property ownership 101. So to help orient everybody about just how is real property owned, and then its basic disposal at death, which is either by a will or without a will. There's trusts will change that a little bit next month when I talk about those, but hopefully I'll be able to put those in context. And so because there's a lot of y'all though that are new and aren't familiar with what I do, I'm an associate extension professor in Department of Agriculture and Resource Economics. I have a 50-50 appointment. I teach classes in agricultural law and environmental law here for CALS, and but 50% of my job is out there with y'all. And so this is the web portal that I manage, just a couple of resources that I've put together over the years with the collaboration of others. This So You Inherited a Farm is the most recent. It's very much targeted at a lot of your clientele who have already inherited this land. This earlier handbook, Plan the Future Farm, was very forward-looking. It was, let's get our state plan together, let's categorize our property, all that. Still relevant, and actually, me and some folks here in ARE are starting the active discussion of revisiting this handbook. But this here is more recent, and again targeted at a newer audience. Both these copies are on the website at this farm succession tab. Just scroll down, and you can direct your clientele there. Here's just an example of some of the stuff that I work on. In terms of fact sheets for cooperative extension, a lot of them ended up here in this workbook, but things as nuanced as the property rights of the surviving spouse. That's something that comes up all the time. You'll notice that the work that I'm doing here in ARE is it will be a little footnotey. I get frustrated by publications that just make a statement and qualify that statement by "this may happen." To me, I want to say, well, so you say. And so I kind of want to know where the law is, where is that rule, so to speak. And again, on this topic of education, again, today, I think, most of y'all are in cooperative extension. Even if you're not, you're collaborating in counties and working on landowner education programs and conservation and other topics. And I just wanted to throw these two out. And for those of y'all who are tired of me talking about land summits, just bear with me a second. This is a format that I worked with Becky Bowen back during the pandemic, and started putting this out there to counties because it seemed to me, after working in this arena for a long time, that it's one thing to go to a cattlemen's meeting, the second Wednesday of every month, and you're going to be the speaker and you're going to go in and talk about taxes or estate planning or something like that. But to actually have it where you're not targeting a specific commodity group, something that's somewhat of a captive audience of clients, you're having just the general public come in the door. And I've found it in the past, and I'm only speaking from my own experience, that it's somewhat challenging to bring in a bunch of people, just general advertisement in the county. Their common, connector is going to be if they own land. But I was talking to Stephen about this before. They may own 10 acres, or they may own 100, or they may own 500. Each of them are going to have different places, different needs, and all that. And so, I've tried to come up with this type of format that will bring in more topics to a half day, a full day, a series. That counties have done that now. And you're not just talking about succession planning and estate planning. You're talking about present use value property taxes. You're talking about land use and zoning, bona fide farm, and conservation programs, things like that. So it's a little bit more global, but I think it addresses more of what individuals are coming into that extension center to hear about. Contrasting that with, I guess, what we would call more intensive farm succession workshops. And I'm presenting this to y'all because obviously you at some point you're the host for these. And this is something that I did much earlier in my career. I'd get grants from Risk Management Agency and whatnot, and bring in a bunch of academics, and we talk about these topics. I think it's one whose time we could probably bring back. I think the land summit is something that just any county, it's pretty easy to come up with, you can do. I think with the farm succession workshops, if you're getting more into this concept of intergenerational transfer of working assets, working farmland, I think working with the commodity groups is probably the way to go there, because again, you get somewhat of a captive audience. many of whom in that room are going to have what I call going concern farms. There's enough there that they can actually have that business transfer to the second generation, which is a lot of times it's one of the goals in what we call farm succession. So putting just those two thoughts out there for y'all. And I was asking myself, this question also, because in writing these materials, I mean, here's what we know, and FarmLink has surveyed y'all about, what questions are you getting? I know what questions I get by phone calls and emails and questions directly from y'all on somebody that's come into the office and asked a particular question. So that's sort of how I'm keeping tabs with what's going on. But I'm always asking myself this question is, what is the extent of our role? And I may have just answered it. And I think it's trying as best we can to, put together resources that explain topics and bring in people like Innoland Summit that actually is in charge of the Bonafide Farm program, or actually is in charge of the present use value property program. We're the education interface, so to speak. The other question, this is a bit more global, is, traditionally, at least when I started out, I just had this vision of a, again, now what I now call a going concern farm. And it had all the ingredients there for the next generation to be chosen and move right on in at some point and take over that farm, and the parents sort of kicked back and all that. That's one scenario. It's a fractional, like a small percentage scenario, I think, of what we're facing when we're talking to clients out there about, what's on their mind about their land and what their goals are. And then the bigger question, we've always just sort of taken it on faith, but it's one question for my part, I'm sort of wanting to answer and finding out more about a challenge we all have in extension is, what is our success rate? What is our impact? And this, of course, this is maybe an academic ARE type question, but it's just something that it's always sort of there in my mind. I have some observations, but I just jotted this one down. At the end of the day, all of this farm succession talk, at least our role in it, if we're spending public money and our time, which is public money to do this, is that the goal is to keep the asset working. And again, for ecosystem services, actual agricultural production, forest, timber production. But at the end of the day, and I've just come to the conclusion, we talk about farm succession and all this in a lot of different ways, but ownership of the land is really the critical outcome. Ownership of who is going to use and manage that land, not just for income, but to keep that pervious surface available, keep streets off of it, keep the type of land use off of that land that we associate with farmland loss. And I always say that having land, owning the land with a loan, is the laws on mortgages and foreclosures are much more landowner friendly than our laws on renting land and leasing land, which is usually just a matter of contract, and there aren't protections built in place when your landowner comes to move you off for whatever reason. So my background, I think all y'all know this. I've sort of pointed this out, but I just want to say that, I've been in private law practice for, I call it a decade. It wasn't really quite that, but I've always kind of been around it and doing that until relatively recent times. But that's all of these ideas, these observations, and you notice I've changed my slide from this lawyer's observation to this legal educator's observation, because I've very much consider being a lawyer as part of my educational experience background. I'm bringing that to the table, but my role now is that of an educator, not the person who's crafting the actual language. So my observations over the time, and really, again, what we're trying to do and what we're trying to tell audiences is try not to give their heirs, which I'm using that term not quite legally correct, but the people who will come into ownership of this land after we die. And it's one thing to say, don't give them undivided interest in land. It's trite to say that though, because a lot of folks aren't in the situation where they have enough assets to go around, and the best they're going to be able to do is a simple will that really wraps up their affairs of their state, but does not take the extra step of dealing with how the people who come into ownership of that property are going to make decisions about that land after they're gone. And so, as a practitioner, when I was working, and particularly with folks who have larger asset portfolios of land, and particularly when there's a going concern farm, was really to get down into it and look at what they had, the different parcels and their relative, their estimated values, and try to come up with a plan to where each person's getting their own. Now, either today or next time, I'll be talking about options. I think it's my preference has always been to have if I can say children, remember the children are usually going to be in their 50s and 60s when they're coming into these land interests. It's fine to divide up the parcels, just create some option agreements. So the family, has the opportunity to buy. There's a way to an internal marketplace that you're able to set up. Estate tax, always on folks' minds. We have quite high exemptions. I think I covered them in this deck, that were the results of the Tax Cuts and Jobs Act of 2017. That law is going to sunset on midnight on December 31st of 2025. 5 years ago, that was in the future. Now it's just 2 years over the horizon. And so my guess is that our estate tax exemptions won't go back to what I would say. Most folks that you work with do have family memory of when the estate tax was back at around $1 million. And there are tales of loss or having to pay the tax bill, things like that. A lot of times those are apocryphal. A lot of times people have heard that happening. And it may or may not have happened, but those stories are out there that happening. But the estate tax sort of looms on the horizon, but the exemptions will probably stay well above that of most of our clientele, their wealth. Land dispositions must be in writing. The comment that the uncle or grandparent makes, or whoever says, all this is going to be yours. Don't worry, I've set it all up. It's all going to be yours. That doesn't mean anything unless it actually is in writing. Our basic statute of frauds and our North Carolina general statutes states that all dispositions of a defensible right and property, one that you can actually take to court and claim as yours, must be in some form of writing. And I'll review this a little bit later, but that writing is well formed at this point in things like deeds and such like that. Always in the background is present use value property tax. At some point in the relative near future, I'm going to do a webinar on that program and some other land use topics. Sometimes when folks are making decisions about how they're going to divide up their property, they might decide to carve out a parcel that won't qualify anymore, or they take steps with their land without knowing that they actually are qualifying. And normally how that's going to happen is that they just haven't had any income records for the several years. And the county by statute reviews 1/8 of all PUV enrolled parcels each year. It's an octennial audit, so to speak. Your property is going to be audited every 8 years, but that's plenty of time for your property to fall out of qualification without the county knowing. And then once you dispose of it with a deed or something like that, the county's going to find out, and an unwelcome tax bill can happen. Again, from my perspective, legacy planning, series of disposition decisions and executions. It's something that takes place, to my mind, over a long period of time. One of the challenges I face now, and being with NC State, is I get calls from former clients who I very, very much want to help and find closure on the next level of their succession planning over the long term, but find that I'm just without the I'm doing other things now, and so I try to help them get into the right hands. And the last thing I'll say on my observations is be mindful, and I say this to the people who own the land, be mindful of leaving obligations behind. A parent, a grandparent can put enormous pressure on their descendants with statements like, don't ever let this be developed, or don't ever, let this not be a farm, or things like that. The right ingredients have to be there for that type of legacy to be carried on without it causing, in my mind, undue stress and succeeding generations, because different people in those generations are going to feel differently about those obligations, and that, in my experience, can cause stress. So I need to get some law here. I'm going to put this out here. I do this with my students and their eyes glaze over, but just want to remind everybody that everything I'm talking about in terms of property rights and ownership and wills, we made up. We just, as people, we made it up over 1,000 years, primarily in England. But our property laws going back to ancient times were usually one of possession, which is now true of personal property, but land is now going to be evidenced of written title. And so we have created the rules along the way that we can write on a piece of paper who possesses this land after we die. And Sir William Blackstone, a jurist writing a treatise back in the 18th century, I thought that was an obvious question, but one that sort of needed to be asked. Let's see. Yes, a couple more observations. I've already talked about the property disposition. I want to put it out there also. I don't know how other folks talk about this, but in my experience, equal treatment of children has been the guiding principle for most estate and farm succession planning. I have not, again, in my limited experience, and I'm going to use the word limited, I only had so many clients. It was rare, if ever really, that I saw someone that cut somebody out of the share of the wealth in order to keep the farm going. There are a lot of other things that can be done, but just making that simple decision of all the land's going to go to you and you can have this, the gun collection or whatnot, is just, to my mind, it certainly can happen, but it's just not really a thing. And so the other question that you've heard me allude to this, and I'm as we do this type of education work, and I'm saying we, all of us, all of y'all on this Zoom, we're talking about transfers of a going concern farm. Is that what we're talking about in terms of farm succession? Because we're talking about, business assets and doing things like that, or are we talking about just transferring the assets at death sufficient to help somebody if they want to continue farming, getting 20 acres out of the 100, and that's what they're going to do with it. And so, I would say that, again, I guess that's more reflective of my thoughts on the different type of target audience that we have with this information. These probably seem somewhat familiar to you. I keep using that image for some reason. Keep land in the family, preserve legacy. That's always a strong one. Preserve wealth, avoid taxes. I usually emphasize the preserve wealth because statistically, families are not losing wealth to pay estate taxes. It's just not a common thing. Very, very, very wealthy families do, maybe without sufficient planning, and normally with that much wealth, they have planning options available to them, or at least the expertise available to them to dramatically reduce their tax burden at death. But for most people we work with, it's going to be that's not going to be a real issue. Providing equal treatment, equal wealth for family members, live in a comfortable retirement, keep a going concern business and operation, provide farming opportunity. This is one that I've always sort of tried to hammer on, that if you have stated that your goal is to keep this land in farming, you very well may be looking outside of your family to do that. It's not that you're giving away anything, but there are ways to transfer this land that can give somebody else a start, a foothold, an option to purchase some of it, any number of scenarios. and another one I mentioned earlier, insured land is never sold for development. Again, I try to help folks keep that in perspective, that things do change, and most folks that we work with have seen things change in their counties before their eyes in their lifetimes. So, okay, let's actually get to I'm going to throw this in there too. I'm trying to get to some law, guys. Here's the questions we got to ask in farm succession. Is the operation itself, if it's a going concern farm, is there enough land in the area to rent for expansion? If it's a commodity operation. And for a lot of us, the answer is not, is no, because it's either the land might be available for rent, and landowners who have qualifying land for present use value need a tenant. If they're not themselves farming, they need a tenant to produce that income to stay qualified and keep that low tax bill. But it doesn't mean that land, they're holding the land for farming. They're just holding it for something else that comes along, a non-farming development opportunity. So a lot of in too many areas in North Carolina, there just isn't enough land to bring in enough acreage and income to be able to support enough families for there to be this generational succession. Or, and here's the big or, and I saw this play out, it has been playing out with a number of folks that I worked with over the years, is that the next generation develops a pretty solid agritourism enterprise, or something a lot more intensive than just row cropping commodities or just raising livestock for market, or for the regular sale market. And that becomes the thing that is going to where that next generation income is going to come from. Another tool is in a lot of these situations going to be life insurance. I saw this play out a lot of times. It does work. The question is, are the policies available at what you can afford? Because getting whole life policies to be able to equalize estate distribution with cash, those aren't necessarily cheap. But many families use that as a land substitute so that money can go to certain children, and the one or two that are there and have invested their time and career and continuing on the farm operation on that land, or a farm operation on that land, will now come into ownership to do so. Other questions, but let's just let's keep moving along here. Okay, let's talk about some law. So property. When we talk about property, we're talking about two kinds of property, and the law treats them very differently. We have what's called personal property, and that's things that are movable. And the easiest way to think of what's personal property, it's anything, excuse me, that is not affixed to the land, which of course we call real property. Our intestate succession laws treat it differently. Our wills and probate treat these types of these assets differently. So it's helpful to know what they are. But generally the term, and I pulled this just straight out of Black's Law Dictionary. That's our, on my shelf. That's our, as lawyers, our go-to dictionary for how legal terms have been defined over the eon. And it's not just one unified right, it's an aggregate of rights. And y'all have certainly heard this this analogy. This is what they teach us our very first day in Property 101 in law school, is that land is it's a bundle of a bunch of different rights. We refer to it as the bundle of sticks, meaning that if I've got a bundle of sticks, I only have two pencils here, but if I decide to take one of the sticks out of the bundle and transfer it to another person, and more specifically, usually to another parcel, that's generally, well, you can transfer these rights to people for their use that's unique to them, or you're transferring it to them as owner of another parcel, and therefore the parcel is the entity that benefits from that transfer. But all of these things, water rights, the right to timber, the right to sole possession. Anytime you rent a house or you lease a field to a farmer, you're transferring that stick of sole possession to share with that farmer. Right to subsurface materials, right to right to take wildlife. You can lease that out to a hunter. So, and I've barely scratching the surface here and how you can identify these rights, but just understand that that's generally with real property specifically. You can do this with personal property too. You can lease out equipment for sure, lease out your possession of it. But generally, you're by your instrument, by your deed, and timber's the best example. When you cut timber, you're by deed severing that stick, no pun intended, from the property to the timber buyer who's going to sell it to the mill. And so that's the bundle of sticks concept. The nature of property, I'm throwing some terms at you just so you, when you see these wherever, just know that land, real property itself, falls under this maxim. I did not take Latin, sorry. I took French. But this suis est solum ejus est usque est solum et ad infernos. Sorry to you folks that studied Latin in high school and college. But whose is the soil? Whose is the soil? His is even to the skies and the depths below. What does that mean? It means that fence line is just really a surface marker for the property boundary. But the owner's property boundary for that tract goes all the way down to the center of the earth, in theory, and goes all the way up to as far as you can go, in theory. And so there are things that, particularly in the air above us, because of the commercial use of aviation of all kinds, we've allowed the government, we the people, to invade that airspace with regulations and law. But generally, going down below the subsurface, that's why we have subsurface mineral leases and why we're selling. If we have shale, oil, or gas underneath our property, our real property, that to get at it, even from an adjoining property, it requires that they're crossing a property boundary in the subsurface. When you see the word estate, just know that's a Latin word for status. It just means it's a description of how one holds the land. What's their present relationship to the land? Very much related term is tenancy. We generally think about that as somebody who's renting the land for whatever use, but the term really means it's what is their ownership interest in their land. So you'll hear me talk about that in that context in just a bit. Always know, and I can talk about this in a much later webinar. Property rights are recognized by the United States Constitution, Fifth Amendment. The law that governs our rights and property comes from the common law, which is that body of law developed in England, again, going back prior to 1066 even, and developing over time, which we adopted here. And I say we from an Anglo-centric, because our country was founded from an Anglo-centric demographic viewpoint, that the rights and these tenancies and estates and property are a matter of common law. And that's what governs our rights against every other person in that property. Our rights against the government are basically, they're recognized by the U.S. Constitution, Fifth Amendment, but the government can always take your property. It's just that they're required under the Fifth Amendment to pay just compensation, and their use of that property is going to have to be for public purpose. So, but it's really the common law that's going to deal with all the issues of people versus people. And so family versus family, all of that. Yes, so I mentioned earlier, you can't just verbally transfer property. You can't say, hey, this is going to be yours, and then you go and try to defend that transfer in court. Statute of frauds. I didn't put the North Carolina Code section here, but it's enshrined in our state statute that all dispositions of land must be in writing. And so this is a very old law. You can imagine it came about because people were going into court and bringing in their friends and claiming that somebody told them that this was theirs and things like that. I carve out as an exception agricultural tenancies for 1 year. I'll point that out here in a second. And then sometimes you have what I call time or necessity exceptions. And that's where you might have a landlocked piece of property and you can go to court, and under a North Carolina state statute, there is a procedure by which you can force a easement across another person's property. We call it a cartway. Only applies to natural resource use of the property. It doesn't apply to being able to use that land for residential development. I had to kind of send one of those, as we all do, those bad news emails. The other day, someone had a landlocked piece of property, and I really couldn't come up with a theory by which they would be able to force an easement to it. Not saying it can't be done, but we also have adverse possession, and that's what we know as squatters' rights. That's when you have occupied property openly, notoriously, claiming it as yours for a period of 20 years. The court will then recognize that that is your property, that you can't be ousted by its original owner because you have been on it for so long. When you hear the term, that possession is 9/10 of the law, sort of true with personal property. Challenge with personal property, unless it's titled. You have livestock that are going to be registered. You have your farm equipment that's not registered with the DMV, but certainly a lot of it's going to have registration with with original purchase lenders and things like that. Ways to identify it. But a lot of times, the property that can't be specifically identified other than description, if you think that somebody else has a piece of property that's yours, personal property, you have to establish ownership. And the only way to do that is in court. And really the only way is with verbal testimony, with other evidence, things like that. But the person who has possession of the property, they're sort of on the winning side until you go to court and change that, change the status quo. So yeah, it's a thing. So ag tenancies, real quick, I get a lot of questions about this, but I'm putting this as an exception to the statute of frauds. A landowner cannot turn off a tenant who's farming there during the crop year. You'll notice here that there are different notice periods that a tenant and I think not most, but majority of field use in North Carolina is done on handshake. And all the statute says is that if you're there on that land and you're farming, the landowner has to come to you 30 days prior to either January 1st or December 1st, depends on which county you're in, and give you notice. Doesn't say written notice, it just says notice. That your tenancy will terminate. If they don't do that within that 30-day window, you have, as the farmer, have the right, arguably, to come back on the farm and farm it for another year. You could defend that in court. That's a likely outcome there. But if the property changes hands during the year, it's sold, the owner dies. My understanding of North Carolina law, my research on this is that that tenant, they say that the estate has been determined. And so what that means is that your promise, the verbal promise that you could stay on that land, died with that person, or was the person gave that up when they sold the property. And so no notice is required. So when the landowner comes to you, if you're farming on land that has been sold or the owner has died, do not assume that you are automatically going to be able to come onto it next year, or that you were owed notice by the current landowner, because you're not. I've tried to deal with this in a fact sheet, which you can read. Adverse possession. Okay. While we're here, is not easy to prove, but you hear enough about it, I think. Generally, adverse possession comes into play when you have encroachments. When you have somebody built a shed that encroaches across the property line, and they've had it there for the requisite period of time, 20 years. I could see this being very common with fences, where the property line there was some dispute or misconception about where the property line was. one person put up a fence and on somebody else's property, and they never said anything about it. And then the person grazed their livestock right up to it and all that. This is quite a common thing. When the landowner upon whose land the fence is tries to move the person off with an action to quiet title, this is a defense that the person who has the fence there can bring up. But it's not that easy to prove, but it is a possibility in law to actually have now claim to that ground. How can land be owned? Sorry for the small print, folks. But these are basically these are two categories that I've divided up into three. These first two here, joint tenancy and tenancy by the entireties. Joint tenancy with right of survivorship is a concept at common law where two or more people own a piece of land, and it could be personal property too, but from that here on out, let's stick mostly to land. At the same time, but how they came into possession of it, the deed that transferred it to them, used the terms as joint tenants with right of survivorship. And what did that mean? It just means that each owner has an undivided fractional interest, but they have possessory interest of the entire parcel, meaning one can't tell the other they can't do this here, they can't do that there. And they have the right, the three of them equally have the right to possess the entire parcel, but their ownership interest, their fractional ownership interest is going to be a fraction. What distinguishes that type of tenancy, ownership tenancy, is that when one of the owners dies, the other owners subsume the right word? So absorb that interest. And so if you have three people that are joint tenants with right of survivorship, when one of them, and so they each own 33.33333, when one of them dies, the remaining two are going to own 50% each. The tenant that died, the joint tenant that died, their interest does not go through their estate. It's not even a part of their estate. It's automatically determined at that last breath to be the ownership owned by the others. This is somewhat rare in modern times. I've not really come across this. Every once in a while, I see a case where they did have land deeded to them this way. Where it is common, this type of ownership is going to be what we call tenancy by the entireties. And because our marital laws only recognize a marriage between two people, this is a spouse and spouse legally married. Not North Carolina does not recognize common law marriages as they do in South Carolina. You actually have to have a state-sanctioned certificate of marriage for this to apply. But this describes property that is purchased by married couples and both their names appear on the deed. Generally, the law is going to assume, it does this by statute, that when both names are on the deed, it assumes that the property is tenancy by the entireties. So just like with joint tenancy with right of survivorship, that's what it means. It means when one spouse dies, their interest, their undivided 50% interest, and again, remember, it can only be 50%, can't be, there's only two people in the marriage legally. The surviving spouse is going to own that property outright. And this becomes one of the issues that we have in farm succession, because the only thing that's certain in law is death and what happens to property at death. Up until that time, we have some nuances for mental capacity to be able to dispose of the property in writing. Being of sound mind, I can execute this will. But a single owner, regardless of how old, the law always presumes that they can remarry. And so when that person remarries, I do want to make the point here, and I don't think I have a slide coming up that drills this down. Under North Carolina law, land that you bring to the marriage, property that you bring to the marriage, is not considered marital property. It doesn't mean that the other spouse automatically is going to get some of it in a divorce. There has to be a very complicated accounting and an inequity, a balance of inequity, where a court may order that land that was brought to the marriage, some of that now has to go to the other spouse. One fact sheet on that note I didn't put on there was the property rights of surviving spouse. I encourage all of y'all to read that because there's some surprising things in there. A surviving spouse can elect, if they so choose, to have a life estate in all of the property of their deceased spouse, even land that was brought to the marriage, family land. So that's always something out there that's a possibility. But generally, property that's purchased, both names are on the deed. It is legally possible for one spouse while they're married to buy separate property. But when push comes to shove, if the marriage dissolves, accounting for where the funds for that came from may change that particular formula. So that's joint tenancy. That's where one owner dies and the other is owning. Tenancy in common, I'm going to argue, is by far the most, we don't know statistically, but for a lot of our farmland in North Carolina, particularly after the death of the parent, so to speak, the person in later age, 80s and 90s that passes from the scene, a lot of that land is simply going to be divided up share and share alike among those either at law in the intestate succession statute that come into ownership, or those that are identified in the will to come into ownership. And so this is where we run into the challenge in farm succession of how do we wrangle these interests if these concurrent owners each have an undivided interest, but more importantly, an uninterrupted right to possession. And so the challenges with the property, one of the primary challenges is that using that property as collateral for farming is going to run into immediate problems because the other owners have to encumber their interests to that loan transaction. And that's not something that everybody's going to be interested in doing. And so, and also making decisions about where you're going to build, things like that is always going to be up for contest. When we take this to its extreme and you have multiple generations passing law by intestacy, or then that's when we get that term heirs property. It's a descriptive term meant to describe a situation where several generations of property rights have been handed down, and the owners are not inside of a lineal family. So y'all probably know this, or you'll see this, but NC State and A&T are doing a series of programs on heirs property coming up starting next week in Guilford County at the A&T farm there. So look online for those. We're having it in different places of the state, so I encourage all of y'all to come check those out. Life estates. I realize I'm kind of going to run short on time here relatively soon. Life estates are also very, very common. How is a life estate created? It's created in a single deed where the owner, the person that owns the land, is going to draw up and have a deed written up by somebody, and they are going to transfer it to another individual, but qualify that transfer with language to the effect of the right to remain there for the rest of their life. And so the interest of the person they've deeded it to by deed, which is then recorded, is vested. It's not coming undone. There's not a mechanism by which their property is going to come undone. Both sides of that deed have to make that change in order for that to happen. And so what is the current owner obligated to do? They have to pay the property taxes. They have to keep it insured. They have to ensure there's no, common law, we called it waste, basically depleting resources. Where this comes up most time, at least in my experience, is when I was in practice, I was on two sides of this issue, where the life tenant wanted to cut timber, and the the remaindermen, as we call them in law, said no, because they can say no. The owner can't on their own sever that stick, because that stick has a vested remainder interest in the person who is also named in the deed. There is and it's unique in the South, I think unique in the country, a section in our partition statute that allows life tenants to go to the court and petition to have the timber severed. And so that's a possibility, but I always encourage folks that if you are going to do a life estate, I did not favor doing these on tracts of land, on farmland or on forest land. Fine for residences, fine for small holdings, things like that, at least in my view. But if you're going to do it and you have natural resources on there and you need to use them, then go ahead and reserve those rights, and you can certainly do that. There's an article I'd written for the National Woodland Owners Association on that. Don't think I need to go through the example, but it's a little bit about documents of tenancy and title. Why do we, when we go to buy a piece of land, first sign a contract to do so? Without that contract, the owner of the land can decide not to sell it to us. And so in the modern era, when we're going to buy a piece of property, particularly if we are buying it with purchase money from a lender, we're going through a process of due diligence of ensuring that the title to the property is vested in the person who's selling it to us. That's where we do title searches. We do other investigations like zoning and various things. We often survey to look for encroachments, things like that. But it's a waste of time to do all that work unless you actually have a purchase contract in hand. And so that's that primary document when we're selling land. It's going to be that purchase contract. All it is a promise to convey title. And generally it's going to be conveying title by what we call a warranty deed. A general warranty deed is your most common form of deed of transfer, whereby the owner who's transferring the land guarantees in that document. In reality, it's just words on a page, but legally enforceable if needed. Guarantees to the transferee that they have title to that property. Well, that's fine, but what if they spent the purchase, the money that they got from the sale already? Or what if they don't have anything else or any other property? They're a potential defendant without assets, which is the worst defendant, and one you have a challenge finding a lawyer to go after. That promise is still there in the warranty deed, but now we generally handle all loan-backed transactions with title insurance. Excuse me. And that is, if there's a defect in title, if for some reason that the title search did not reveal that there was a uncanceled deed of trust and some bank somewhere suddenly, assert some sort of right, there's an easement we didn't see, or a timber deed that wasn't caught. That's what the title insurance is for, is to pay the money to rectify that defect in the title. The secret for y'all's edification behind that is that unless you're a licensed attorney in North Carolina with an insurance policy, a professional liability insurance policy, it's relatively impossible to certify title for a transaction, because the title insurance companies only work with lawyers who have professional liability policies. Why? Because if I screw up and the title company has to pay out, who are they coming after? They're going to come after me because I screwed up the title search. But other documents, of course, the deed of trust, that's what secures a purchase money loan. It gives the bank the right to foreclose on that property and take possession, actually not take possession, but a right of sale. Banks don't repossess land, they sell land. Easements, that's a whole nother topic, but one that is very, very common in our work, because we're always getting questions. I say we as all of us, I'm not doing the royal we, of people that have land that they don't have access to, or they're trying to figure out, do they have the right to cross somebody else's property? Or often, do they have the right to put a berm up at that access point and keep people from coming on the property? the best easement is not an easement. The best easement in my mind is when you're subdividing a parcel of land to sell it to someone else, is to create a right of way, create a strip of land that goes out to the public right of way. In absence of that, the second best thing is going to be have a recorded easement either in the deed of transfer or a standalone document that's in the chain of title. On that note, well, I guess that's my next one, but leases, I did mention, some of y'all might have caught this when I was talking about leases here. Just know that if you enter into a lease transaction on a piece of property and it is in excess of 3 years, it is valid. Say it's a lease for 5 years. It is valid against the owner, and it's valid against the heirs of that owner, the people who take from that, who inherit from that owner, without that document having to be recorded. However, if the owner sells the property for money, a purchaser for value, sells it to a purchaser for value, unless that 3+ year lease is in the chain of title, it can be disavowed, meaning the new owner can then have that tenant be moved off or block their access or whatnot. The question about, well, does a statutory tenancy for the rest of the year apply? I'd argue yes. I haven't seen a case on that, but logically that seems the case. Let's see. Oh yeah, like I just said, the warranty deed. I just want, for terminology, for all of y'all, it's a quit claim deed. It's not a quick claim deed. A lot of times people refer to it as a quick claim deed because it's something you just draw up real fast. It's a quit claim deed because all that's happening there, it's not as if the owner, the person who owns an interest in that property, is transferring their interest. They are, but all the document's really saying is that they will make no claim, they or their successors will make no future claim to any ownership interest in this piece of property. They're quitting their claim. They're giving it up. And quitclaim deeds are very common when we're just trying to resolve title, deal with encroachments, things like that, or just transferring land into a trust or a limited liability company or something like that. And so, those are still very, very common. I'm going to move past that. I'm going to move here as we're talking about land, and I've just got a few minutes left, and I think this is how I want to do our next session. We'll start with the family that my hypothetical family, real in cinema, but not in present day, and use them to illustrate these property points and use them to illustrate the use of wills and trusts and LLCs. So the title searches, generally, and this is going to be something that we're advocating for when we're doing heirs property programming, it's somewhat of an art. I think all 100 counties now have digital land records. And so you can go online and do this. That's why I was able to practice in Hillsborough, North Carolina, and have clients in Currituck County, because I could go online and do a title search. But generally, you're finding out, who owns the property through a title search, and it's just a basic part of any land transaction. But this is when I mentioned earlier about buying property and knowing whether there's a tenant on it, buying property and knowing, or being a tenant on property and having it, since the owner then sells it, and being able to protect your lease. That's something that's got to be there in that chain of title. Otherwise, the new purchaser is not going to know about it. Generally, we only search title back 30 years under the Marketable Title Act. There are some exceptions, mineral rights, railroad rights of way. That's not an uncommon thing either. Now, we've largely abandoned our rail infrastructure or a lot of it in North America, but those old railroads, now ancient by our standards, there are still various rights in property that someone might have, depending on how that railroad was built through there. And so for next time, if we're keeping this to an hour, I've gotten halfway through the slide deck, and I know the description, and my apologies for this, folks, said, we'll go through wills and trusts and heirs, or wills and heirs property. That's something that's very, very easy to roll into the next topic, because what we're going to talk about next time with all these rights and property is where do they go, because we can't take them with us. Our family will be the Corleone family, and I've tried to construct as best I can there the lineal descent of that famous family in movies. Noting also there's an illegitimate child over here too from Sonny. Not sure how to treat that yet, but what I'm going to do in our next, to give you a little bit of preview, is to go through and deal with these issues of how the property is disposed of. I'll give you the figures on the estate tax and how and when that's relevant, but look through different scenarios of when people die and whatnot, and then moving forward further, going all the way down to using options and tenancy and common agreements, what a trust does to the family situation, different types of things like that. So again, apologies for getting too hung up, as I often do in the very beginning, but I think that'll fit nicely into an hour program when we get together again. So I encourage all of y'all to come back. Questions? Comments? What are we doing here? All of
Andrew,
that.
I've got a question. Like occasionally you'll hear people mention like a 1% deed. What is that used for in estate planning?
Okay. So there's I'm going to admit my ignorance on something, and I've been meaning to research it and write a fact sheet on it. There's this thing called, well, my experience with percentage deeds is it's been used in the past to try to reduce the person's ownership footprint for tax purposes. That's how I saw it used. I'm sure there's other reasons that folks would use that, and I've sort of heard them. They're just not coming to mind, so I don't have a good answer. The negative, and I'm focusing on the negative of using a percentage deed to try to make to get some sort of advantage, is that you now have a co-tenancy. And co-tenancies, we just do not needlessly want to create those. So there might be and I'm certain if people are doing it, there's a reason that they're doing that. It's not necessarily for estate planning purposes. It might be to create another owner in the property to make it more difficult to dispossess the previous owner, but I don't think that stands in the way of it, because you can still have go to court and parse out those interests. So Steve, I'm stumbling around an answer that I don't have. So, but I've seen them.
Yeah, if anybody has any questions, feel free to unmute and ask them or put them in the chat. So,
hey, Andrew, this is Andrew Waters.
Hey there.
Hey, my question is, does paying delinquent property taxes contribute to adverse possession? Does that help you claim adverse possession?
No. Not as a matter of catch up. If you were paying property taxes, you thought you were paying property taxes, or the county thought you were for that piece of property, that would certainly, in my mind, be evidence of open and notorious ownership under a claim of right. But there's no mechanism by which, and the law kind of really guards against this, of somebody coming in and paying those taxes, and then that giving them an ownership interest.
Okay, thanks.
Good question. I would also say that it doesn't necessarily, under current partition law, which I didn't go into either, provide you any sort of advantage in terms of claiming a larger share if you are partitioning the property. It will help if you can prove to the court that you did pay those taxes over time, and the court agrees with you, and they say, okay, you can get your expense reimbursed. That does happen, and I have done that. Anyone? I would encourage y'all to, as you get questions, one of the first resources, I mean, two resources, FarmLink and the Farm Law Portal, to direct your clientele there, because it's likely that in some form or fashion that issue has been addressed. To, I guess, give you a peek under the hood of my extension appointment, what I've been trying to bring to the table is as much as I can from my experience as working in private practice and just really working around the agricultural land space for the time that I have. That usually leads me down a rabbit hole of certain topics, and I tend to be heavy on citations and how I'm coming up with statements in the papers, which I think is critical. And so, but a lot of times there's going to be issues that come your way that a quick search on, if we went to the farm plan, if we went to the farm planning portal, farm law, sorry. Oop. I wanted this part. Normally you're going to you can search out different topics here, there's going to be something in there that it's been dealt with in some form or fashion. And I know I noted that subset of fact sheets that I put on one of those first slides. That's a place where it's papers like that address a lot of these issues. So. Feel free to make some comments to me directly by email. Like I said, as you can see at the very beginning, I'm struggling how to address this topic always. It's one that's just so large. And every family, every person with an ownership interest in land has their own unique situation. And it's very, very difficult to try to capture all of that into one slide deck, one delivery. And I would also, while we're all here, I do have a request that I do for questions that you send me. The best situation is when you, the agent, the specialist, the county director, send me a question, directly from somebody that's spoken to you. And it's fine for people to engage with me directly. I generally prefer that by email, and I know that most, not everyone can do that. The reason I like to have you and the county involved, I want that as part of, your service, but also it's my hope that you learn everything. You learn a little bit from every type of interaction over these real world situations. And so